Good evening, everybody. All my Indian friends, good morning. My US friends, and good afternoon, my UK friends. My name is Santosh Vikram Singh. I am a partner here at Fox Mandal Associates, practicing intellectual property rights law, sports law. And if location still matters, I'm in Bangalore, India. So I would like to welcome all of you for today's session or under our Moving Ahead series. Under this series, we are talking about various aspects of intellectual property. Today, we are here to discuss the recent Booking.com case and its implication on protection of generic marks, primarily in three jurisdictions. Of course, US, that's where it was decided, and very important jurisdiction, Europe and UK, and also India. If you look at this particular Booking.com case, nobody had heard of this registration, and most of the countries or prominent jurisdiction granted the registration way back. In fact, in India, it was granted almost 5-6 years ago, and nobody came to know about it. But it was only June 30th, a couple of months ago, when the Supreme Court of United States gave a ruling wherein they allowed company to register its trademark Booking.com with the US PTO. This became a hot topic, and all the countries, not only IP attorneys, but the brand owners, they started discussing this case. So it became very interesting for us to get into this case and see what are the merits in this case, and what are those findings, what kind of judgment people are making out of this decision. All right. So to discuss this case in detail, of course, since this was the US Supreme Court decision, it was very important that we have some US IP attorney to give his or her perspective on this case. It was very kind of my friend Naresh to agree to my request and join this discussion. So we have Mr. Naresh Kilaru, who is a partner with Finnegan in US, who has agreed to come and give his perspective on this case from US point of view. Also, I have Clare Cornell, who is also a partner with Finnegan, in UK. She is going to bring on table UK or EU perspective on this case, how that jurisdiction is looking into this case and how they dealt with this case, back then. So, Naresh, thank you so much for taking time out and joining me today.
Thanks for arranging it, Santosh.
Claire, thank you so much. How you been? And I hope you find this interesting.
Thank you for inviting me to join you.
Welcome. So first thing first, to start with the disclaimer, of course, all the views expressed by all three of us are personal views and not necessarily of our firm's views. So it's disclaimer in any lawyer's, the webinar or talk you find. Now, starting the discussion, Naresh, to start with, being an IP attorney, you've been practicing IP law for many years, and when you heard of this decision, on 30th June or post that, and in fact, if I'm not wrong, this was the first US Supreme Court decision ever pronounced on phone call or over internet, not in person. So what was your reaction like when you heard of that Booking.com was allowed to register? And here, when we are talking about Booking.com, it's mainly for class 43, which relates to online registration of travel services. So what was your reaction, first thing, to start with, Naresh?
Sure. In some ways it's an unremarkable decision, and in other ways I think it does break some new ground. The PTO, the US PTO has had this rule, which has essentially been a hard and fast rule for quite some time, that if you combine a generic term with .com, that combination automatically results in a generic term. And then the PTO likes to have these bright line rules for examination purposes. It gives examiners a very clear guide to have certain bright line rules when they examine applications to issue refusals. So they had this rule, and what the Supreme Court basically said, of course, it went through the appellate courts, and ultimately the Supreme Court ultimately said, hey, look, you cannot, there is no bright line rule with respect to genericness. You have to look at it in terms of the marketplace realities and the marketplace perception of actual consumers, which of course makes the examiner's job much more difficult now that there is no bright line rule. So that part of the decision was not that remarkable, because the Supreme Court was basically relying on decades of jurisprudence that trademarks ultimately are tied to consumer perception. And so the bright line rule here doesn't make sense. The part of the decision I thought was interesting and might have future implications is that the Supreme Court has basically said that generic terms now, prior to this decision, generic terms, the definition of a generic mark, of course, is that it can never serve as a source identifier. And now what the Supreme Court has basically said is that if you put enough branding and advertising behind something, that you can potentially convert a generic term into a trademark. So that does break some new ground. And so, we have to ask ourselves, is there such a thing anymore as a generic term? Because, or a term that is inherently or by nature generic that can never function as a trademark? And I think based on the decision, the answer to that is no, because the Supreme Court has basically said that there are no bright line rules, and as long as you can satisfy the standard and put enough evidence forward that something that the relevant consumers perceive it to be a brand or a source identifier, that it can potentially serve as a trademark. So those were my initial takeaways.
Fantastic. Claire, Naresh spoke purely like an IP attorney. And here I would like to twist my question is that, of course, whether this case post US Supreme Court decision in July did make any noise in UK or Europe at all. And you being a consumer first and IP attorney second, what was your reaction like?
So the decision was fairly well published on the IP scene in the UK. I think always we look at what's happening in terms of sort of significant markets. So the US market is always important for companies in the UK and Europe. And obviously for me, working for a US firm, we need to know what our colleagues are handling. And I mean, as a consumer, Booking.com is certainly a trademark that I recognize and have grown to know as an indication of origin of this particular booking website. So yeah, I was interested to see the decision, and I guess how much noise it made in the US and how significant it was, where it was comparatively quiet in the UK and Europe, where procedures just happened as normal and the mark got registered after a couple of years of examination, but without going through any significant court or appeal procedures.
Fantastic. And in fact, there have been a lot of talk about around this case, and a lot of publication around this case in India and elsewhere. And what I've noticed that a lot of people, I wouldn't say what category of people, are misinterpreting it and somehow kind of concluding it too fast without reading the judgment in detail. So to start the discussion, Naresh, we would like to start with the PTO, what happened at PTO and how this kind of application transpired, or this case transpired generally in India and also elsewhere, whether it's the UK or US, in order for a mark to be registered is the mark has to be distinctive. Now, distinctiveness, whether it's inherent distinctiveness or acquired distinctiveness. And second is that the mark should not be descriptive, should not define the characters and quality of the mark. Interestingly, this application was filed in India in around 2012, and within a couple of years, the application was granted, and we got the registration. The similar kind of objections were raised that the mark is not distinctive enough and is descriptive, but very routine response were filed, and they got the grant without much trouble. Now, looking at USPTO, how they refuse the registration, concluding the booking.com is a generic term for online hotel reservation or travel services. How do you handle objections like these, where you find these generic terms, where you have objections? These are not a generic term and non-distinctive and descriptive at a PTO level. What is kind of preparation you have to do to overcome these objections?
Sure. The strategy is definitely different depending on whether the refusal is based on genericness or descriptiveness. So those are two different categories that are there in the US. And so if it's generic, I would say 90% of the time, the arguments are basically legal in nature, as opposed to submitting factual evidence. So for a genericness refusal, you may submit case law, you would of course submit legal arguments, but you would typically, at least before this decision came out, you would typically not submit survey evidence. Survey evidence would typically be reserved for a litigation context. But now, given this case where the Supreme Court did take into account, at least indirectly, it took into account the survey evidence that was done in the lower court, I would not be surprised to see if more parties were to submit survey evidence to try and overcome genericness refusals. For descriptiveness refusals, where the PTO is saying, this can potentially function as a trademark, you just have to show me that enough consumers recognize it as a trademark, that refusal we would typically submit, in addition to legal arguments, we would submit factual evidence, either consumer declarations, customer declarations. Sometimes we do submit survey evidence to overcome descriptiveness refusals. So that is survey evidence with respect to descriptiveness refusals has in fact been more common.
Okay. Interestingly, in India, more often than not, we rely upon registration of similar marks or this particular mark outside India and those major jurisdictions. Does USPTO also look at the registrations in other jurisdictions and whether that carries some weight?
It does not, and there's very clear cases in the U.S. saying that the treatment of marks in foreign jurisdictions is not relevant.
Interesting. Claire, of course, you mentioned that the application went through in a couple of years without much objection, but you did look at those objections. What kind of objections were cited, and how difficult, and what kind of evidences were produced in order to get the registration?
So the applications were filed in 2010 in the UK and the EU, and both of them took a couple of years to register. The European prosecution file is partly available for public inspection, so I was able to have a look at the objections that were raised by the European Trademark Registry. This application was refused on the basis that the mark was devoid of any inherent distinctive character and that it was a trademark which consisted exclusively of an indication as to the type, quality, or quantity, intended purpose of the trademark. so when the examiner was considering the refusal, they considered that booking.com as a combination didn't deviate and wasn't unusual in the kind of structural language. So it wasn't distinctive inherently. And they considered that obviously booking means to book, and .com was just a designation of a website. So the mark was not inherently distinctive. Looking at the prosecution file, a significant amount of evidence was provided to the EU IPO in order to convince them that the trademark had actually acquired a distinctive character through use. Like in the US, survey evidence was included as part of the response, and that's particularly important from the UK. One of the issues we have in Europe is when a mark is descriptive, because we have 28 different countries and not everybody speaks the same language. Booking.com can be descriptive in English-speaking countries, but maybe doesn't mean something somewhere else. So the most important evidence in this case was to show that it had distinctive character in English-speaking countries. So the evidence focused on the UK market, but was also supplemented by other key European jurisdictions. Other information that was provided included details of financial turnover, the number of bookings that had been made, various questions to those in the field. Generally, it's a fairly high burden at the EU IPO to prove acquired distinctiveness. And I think that because this mark had been used for about 9 years before the application was filed, they had managed to amass a large quantity of evidence to support their case. And ultimately, the office did concede that it had acquired distinctive character and was able to be registered in both the UK and in Europe.
Sure. With all due respect to EU Trademark Office, we find registration very easy. It's easier than India to get any mark registered in Europe. So yeah, and in fact that registration proved helpful in India when Booking.com applied for registration in India. So. Now, Naresh, going to the next level, next to the PTO, of course, they went to TTAB, and TTAB sided with the US PTO, wherein when the Booking.com sought a judicial review at the district court determined that unlike the term booking, standing alone is not a generic. And this ruling was, of course, based on the consumer survey, what we talked about. It was produced before the district court. And that helped Booking.com to get a kind of favorable order at that juncture. Now, keeping that as a background, how these kind of surveys are received by the courts in United States, knowing that perhaps these are not these are tailor-made surveys to support the application or support the applicant, and if the surveys were kind of not kind of supportive, they would not produce those documents. So how these kind of surveys are they common in US?
They are fairly common, especially in these contexts. And that really it was a key strategic decision for Booking.com to appeal this decision to a district court, because when you appeal a PTO or a TTAB decision, you have two choices. You can go to a district court, or you can go directly to the appeals court. But going to the district court, what that allows you to do is submit additional evidence. And that's exactly what they did here. And so they submitted a survey, and it would have been, the PTO would never have conducted its own survey. They knew that. So there would really be only one side of this. Typically in a litigation context, you would have both parties conduct their own surveys, or you would at least, at a minimum, you would have a rebuttal expert criticizing the other side's survey. But Booking.com knew the PTO would not hire its own survey experts, and so it took advantage of that, and it submitted survey evidence. And ultimately, it did not even appeal the survey evidence or the weight of the evidence. It basically only appealed the part of the decision saying that that the PTO's rule that there can be per se generic terms when you combine something, when you combine a generic term with .com, that it can be generic. It appealed only that narrow part of the ruling. It didn't appeal the survey evidence. So even when this went up to the Fourth Circuit and ultimately to the Supreme Court, that portion of the evidence was very one-sided. There was only one view of the survey, which is not typical. So, you know, to your question, are these surveys tailor-made to support a party's position? Of course, you know, survey experts are bound by certain empirical constraints and ethical rules, so it's not as though they can just make up the data, but obviously they have some discretion in the way the survey is conducted, but typically the way you would deal with that is to have a counter survey expert or another expert on the other side, which in this case was absent given the fact that they were up against a governmental entity.
Great respect to US PTO, and you mentioned that whether they would also end up doing a survey on their own, and it's just a very rare for at least I have not heard of many cases here in India where the PTO would go up to Supreme Court challenging the order of the higher court. So US PTO would also conduct a survey if they find something missing.
The USPTO does not, I'm not aware of a case where the USPTO has conducted its own surveys, and I suspect there may be issues with using taxpayer money to try and have the PTO prevail in a case. So, you know, there are obviously financial constraints there on the part of governmental agencies, and that is something that Booking.com was able to exploit here.
So I can say I have a friend in US who cares about taxpayers' money. Thank you for that. Claire, what about in your jurisdiction, how these surveys are received and how these surveys are effective when it comes to supporting evidence at the PTO level or at the court level?
So in cases which relate to registrability of marks, using survey evidence is quite popular and can be quite convincing. The EU IPO has good guidance on the use of opinion polls and surveys, and they indicate in their guidance that if conducted properly, surveys constitute one of the most direct kinds of evidence, since they can show the actual perception from the relevant public. Obviously, where surveys are concerned, there is a requirement that the surveys are neutral and representative. So the questions have to be very carefully put together. Normally, you would commission an independent firm who are specialists in conducting these surveys to make sure that the questions aren't leading and that the sample of people who are questioned is actually indicative of the entire public and not directed towards people who might bias those results. One thing that is mentioned by the EU IPO is that a survey alone can't give a conclusive picture. So survey evidence must always also be complemented by other means of evidence, which I would say would generally be information about the levels of sales or financial turnover or other marketing activities of a company in order to paint a full picture of what the situation is. But yeah, certainly when looking to convince the registry that a trademark isn't descriptive and does have the required distinctive character, then the survey can be a good way of persuading the registry as such.
Unfortunately, we don't have that kind of position in India. The courts are not very receptive of these kind of surveys, and it comes with a lot of riders. So Naresh, coming to your earlier point, you made that USPTO did not question or did not kind of counter the survey results which they produced, and And the only thing they contested in the appellate court was that the booking.com is not a generic term. So the Court of Appeal, of course, affirmed, finding no error in district court's assessment of how consumers perceive the term booking.com. The appellate court rejected the PTO's contention that as a rule, combining generic term like booking with the .com yields a generic, composite. So it's like a two positives make a positive. So the Court of Appeal, affirmed that. And my question here is that, is there a set precedent which is used to determine how a mark to be a non-generic, especially when we are dealing with the generic terms? This is more important considering the Goodyear case where the court had ruled, long ago that by merely adding a generic term like company or Inc., with the generic term would not make it a generic. But here the court ruled up exactly opposite. They said too generic would not make it a generic. So what is your comment on that?
Sure. The test in the US is whether the term refers to the common class or genus of the services. So here, if there was evidence that people viewed booking.com, if people, you have to think of what would people refer to as an online reservation, a service, and would people generically say, oh, well, that must be, you could only call that booking.com. There's nothing else you could call it. That is the only term that, or at least, in a survey context, it would be over 50% of people would say that an online reservation service, the only thing you could call that is booking.com. So that's the legal test, and it varies in terms of how you prove that. Sometimes, as I mentioned before, you can do it purely through legal arguments. In other cases, you may submit survey evidence.
Okay, so you are saying, if I could rephrase it, that it's not about a question of whether these are generic or non-generic. It's also about how consumer perceives it, how it is applied in a specific case, and that's how you decide whether this mark is generic and a subject matter of registration or not.
That's right. I mean, ultimately, the issue of consumer perception is part and parcel of the determination.
Interesting. Claire, coming to you, how courts in your jurisdiction would handle these kind of cases where the question is about generic term, we're not talking about a descriptive term, we're talking about a generic terms, where two generics would make it a non-generic term, or there is something else is needed in order to get the mark registered?
Generally, the guidance that's been provided by both the UK IPO and the EU IPO in relation to registration of domains has been that a combination of a generic or descriptive term with a top-level domain ending such as .com doesn't make a registrable combination. So really the case law would not support registration of a mark of that type without providing evidence of acquired distinctive character. There were a couple of cases that had been determined prior to the booking.com applications in the UK and the EU. For example, in the UK, the tests were considered in relation to the domain name muslimheritage.com. But the courts looked at that trademark and decided that really the perception of the consumer in relation to a mark like that was that by visiting such a website, they would simply find information on that topic. So that's kind of how they would deal with a descriptive term. And interestingly, the guidance from the UK IPO, it gives an example of a term which would be liable to an objection if it was based on physical goods. So the example they give is twist and seal, that as a trademark in relation to storage jars, that would be considered to be descriptive. However, they say that adding the addition .com would give a completely different trademark character. So I thought that was quite interesting. And in terms of my own perception of that, it seems to be not just about the description of a physical activity, but more that the idea that it evokes, and that potentially that it's a domain name rather than being a descriptive term of the properties of the domain. But yeah, I think it's interesting, but generally the feeling is that the combination of a generic term and a top level domain such as .com is not going to make a mark registrable without evidence of distinctive character having been gained through the use of that trademark.
Interesting. A very unrelated question here. If I apply a footwear.com or just footwear in class 9 in UK, and you had to examine that application, would you grant that application?
No.
You are a very tough examiner. Interesting. Naresh, the only dissenting judge, Justice Stephen Breyer, and he gave a long judgment, and why he said he's not agreeing with the other 8 judges in this matter. So I really liked his order, and as he stated, and I quote, the term booking.com refers to an internet booking service, which is a generic product that respondent and his competitors sell, no more and no less. By making such terms eligible for trademark protection, I fear that this decision will lead to a proliferation of generic.com marks, granting their owners a monopoly over a zone of useful, easy to remember domains. This result would tend to inhibit rather than to promote free competition in online commerce. So this is what Justice Stephen Breyer quoted in his judgment. I was looking around and I found that there are a lot of similar marks like e-booking, online booking, and just like these marks are already registered. And unfortunately, these applications never went to court or never challenged, and it was granted registration. So looking at that, do you still agree that what fear he had, that this is going to curtail competition and online commerce trading? Do you really fear that he's justified in his fear, saying that this is going to curtail the competition?
Mm-hmm. Yeah, I mean, I'm not sure I agree with his anti-competitive concerns. At the end of the day, the value of, or the benefit of booking.com gaining this registration is pretty minimal. I mean, they of course, they spent a lot of resources getting it. And yes, maybe they'll have some satisfaction by now being able to put the registration symbol after the mark, but at a very practical level, I'm not sure they gained much, because they have already admitted that the mark is weak. I think they know from a practical perspective they are not going to be able to enforce this against e-booking or booking online. Their scope of protection is most likely going to be limited to the identical mark for the identical service because it's that weak. So, what have they actually gained by getting a trademark registration? Now, Justice Breyer paints this picture of saying, oh, well, the fact that they have a registration might, allow them to send demand letters to other parties, and because many people don't want to litigate, that in and of itself could be anti-competitive, but that's all very hypothetical. So sure, it's possible that they could use their registration for that purpose to try and enforce against parties who may not have the resources to fight them. But that strikes me as very hypothetical.
Interesting. And just to kind of add on to this, would you think this decision is kind of regressive and bad in trademark law from your personal point of view?
No, I think the Supreme Court got it right. I think it analyzed the law appropriately and came to the right conclusion based on all of the precedents.
Interesting. Claire, what would be your remark on Justice Stephen Breyer's dissenting order?
I generally agree with Naresh's opinion here. I think the registrability of trademarks does have to reflect a public perception. And in this case, the evidence supports that the public do perceive the booking.com as an indication of origin. And as such, I think it should be considered as a trademark. Obviously, the scope of protection is likely to be very limited. And always one has to bear in mind that each domain name is in itself unique. So regardless of whether they have a trademark or not, only one firm can have the rights on that booking.com website and domain name itself. So to some extent, they've already got the most valuable part of that domain name for themselves anyway.
Interesting. So I think that covers all our questions. We have got a couple of questions, and let me take this one. Naresh, it says that how would you advise your client if somebody comes to you that I want to register a generic brand? What would be your advice?
I would say, first of all, don't call it a generic brand. And never make that admission. But more seriously, I would say it really depends on what your marketing budget is. If you have, if you're willing to invest in this, and this is a major product for you, and you're willing to put the ad budget behind it in order to convert a quote unquote generic term into a trademark, sure, it's possible. But if you're, for the vast majority of trademark owners, that's probably not going to be a strategy that they're going to follow. For you take wine.com, for instance, which is very similar to booking.com. That I think has now become a trademark. But if somebody came to me on day one and said, I want to make this into a trademark, I would have told them that it's going to be very, very difficult. And, unless you are willing to do the survey evidence and put the marketing dollars behind this to really portray to the trademark office and potentially the courts that you own exclusive rights, that the relevant public, and you're talking about a majority of the US public, which is a very difficult thing to prove. If you're willing to make that kind of investment to be able to show that a majority of the US public associates that term exclusively with you, above and beyond the fact that you exclusively own the domain name, it goes beyond that. So I think it's tough, but it's possible. Obviously there are clients who are willing to go down that road. I would say it's not for everyone.
Interesting. And how would you respond to that, Claire?
Again, the same factors that Naresh has mentioned, but I think the other thing that I would discuss with a client would be getting the timing right as well. What can be an issue is the time limits available for actually providing that evidence. So if I identified something as a potentially generic term, even if my client had used that a lot and potentially had a lot of evidence of acquired distinctiveness, then I would certainly get them to, I guess, get their game in order before they actually applied to register the mark, because the pressure of actually providing all that information within 2 to 4 months of filing can be difficult when you potentially need to have survey evidence, lots of financial information, and things that can just be time consuming to get prepared.
Sure. So I'll take one more question from this one. Interesting question here, and I would like to go to Claire first, is that if booking.com loses that domain.com, they forget to renew that, and somebody else register that, how would you deal with that kind of situation? Can they go back and fight it out?
I suppose that there would be some bad faith issues at this point in time, that if somebody else were to try to secure the website in the knowledge of the reputation and the trademark registration, I think the domain dispute resolution policy, based on the intent to file in bad faith and the similarity with an existing registered trademark, would give you a fairly strong case to have the domain name cancelled and transferred back to what we might call its rightful owner, based on the trademark registration itself.
Thank you. You made it so simple. Naresh, anything you want to add on to that?
No, I think Claire summed it up.
Yeah, fantastic. So any last comment to the brand owners, not to the IP attorneys, that when they have to probably adopt a new name or come up with a new name, what would be your one piece of advice to them?
I guess it would be to really consult with counsel, and not that's not out of self-interest. I would really say that before you try to get a trademark on something, really consider whether what are the chances of you actually being able to get a registration, because every circumstance is different. And the advice you get may be different depending on your particular circumstances.
Claire?
I think in addition to Naresh's comments, the other question to consider is, if you do get that trademark registered, what's its scope of protection going to be, and can you afford to enforce it against those that might be potential infringers, and that you should always have that in mind when you're applying to register a trademark.
Very, very interesting. And what I noticed that with my experience, that the clients or these brand owners, they don't look for the long term. They want to come up with that, okay, something interesting, and they find nothing identical or similar available, and they just want to run with that. And they don't look at long term, how this is going to be received by a different jurisdiction, by the consumers, and how arbitrary or fanciful this mark is, what kind of difficulties that they're going to face. So as you rightly said, Naresh, this is a very wise thing to consult with an IP attorney before they kind of make a decision whether this mark should be good to go ahead for their product or services.
Yeah, and I think Claire raised a really good point, because getting a trademark registration is really just half the battle. And you have to ask yourself, what are you going to do once you have that registration? Because if you don't do anything with it, it's just a piece of paper. And so you really do have to ask yourself, once you get that, what are you going to do with it? Do you have an enforcement program? And what's your enforcement strategy going to be?
Wonderful. So with that, I think we've covered all the questions, and we are well within time. I think we have 2 minutes left. So thank you so much, Naresh, for taking time out, and also getting Claire for me to participate in this discussion. Thank you so much, Claire. It was very interesting for me to understand UK and EU perspective, and of course, Naresh taking us through what transpired at PTO level and appellate court and definitely Supreme Court, and what is general practice. So thank you so much. And I would also like to thank all the participants who took time off to attend this, and I hope they find it they found it useful. So thank you so much, and goodbye.
Thank you.
Thank you. Bye-bye.